हेलो दोस्तों, स्वागत है आपका योर लॉर्डशिप के रिवीजन थ्रू एमसीक्यू सीरीज़ में। आज हम कोड ऑफ सिविल प्रोसीजर के इम्पॉर्टेंट एमसीक्यूज़ को कंटिन्यू करेंगे। चलिए देखते हैं पहला क्वेश्चन। द फर्स्ट क्वेश्चन इज assertion and reason based. The assertion states that a civil court has jurisdiction to try all suits of civil nature, and the reasoning which is given is that the cognizance of a civil suit should be expressly barred. You should try to pause the video and try to answer the question yourself. So the correct answer would be C. A is true but R is false. Why? Because section 9 of the Code of Civil Procedure states that the court shall, subject to the provisions herein contained, have the jurisdiction to try all suits of civil nature, unless of which their cognizance is either expressly or impliedly barred. यहाँ reason में क्या कह रहा है? The cognizance of civil suit should be expressly barred. If the cognizance is barred, how will the civil court try such suit? Okay. It's a very simple question. Then the question is, under Civil Procedure Code, a litigant having a grievance of civil nature has a right to institute a civil suit if cognizance is, and you have to complete the sentence, not expressly barred, impliedly barred, expressly and impliedly barred, none of these. This is a very simple question, and the answer would be A. Not expressly barred. The cognizance of a suit should not be expressly or impliedly barred, and it should be a suit of a civil nature as it has been provided under section 9 of the Code of Civil Procedure. Okay, let's see the explanation. As per section 9 of the CPC, the courts shall, subject to the provisions herein contained, have the jurisdiction to try all suits of civil nature excepting suits of which their cognizance is either expressly or impliedly barred. So ये accepted है. This is an exception. Then the next question is, in which section of the Civil Procedure Code provision relating to suit of a civil nature has been provided? This we have already discussed. Multiple times this question has been asked, and section 9 of the Code of Civil Procedure deals with this aspect. Okay. Section 9 deals with the courts to try all civil suits unless it is barred. The courts shall, subject to the provisions herein contained, have jurisdiction to try all suits of civil nature excepting suits of which their cognizance is either expressly or impliedly barred. And the explanation states that a suit in which the right to property or to an office is contested is a suit of civil nature, notwithstanding that such right may depend entirely on the decision of a question as to religious rites or ceremonies. And second explanation says that for the purposes of this section, it is immaterial whether or not any fee are attached to the office referred to in exception 1. मतलब कोई भी ऐसा क्वेश्चन जो प्योरली रिलीजियस है वो सूट ऑफ सिविल नेचर नहीं होता है और उसका कॉग्निजेंस नहीं ले सकती है एक सिविल कोर्ट। लेकिन अगर वो सिविल राइट से डील करता है और इंसिडेंटली अगर कोई रिलीजियस या पॉलिटिकल क्वेश्चन आता है तो इसका कॉग्निजेंस एक सिविल कोर्ट ले सकती है। बट प्योरली रिलीजियस क्वेश्चन, प्योरली पॉलिटिकल क्वेश्चन, देयर कॉग्निजेंस कैन नॉट बी टेकन बाय अ सिविल कोर्ट. There must be a civil right of which the cognizance can be taken by a civil court. Right to property is such right which is protected under the statute and under the constitution, or the right to an office, if it's there, is contested in a suit of civil nature, notwithstanding that such right may depend entirely on the decision of question as to religious rights. Like right to an office of mahantship might be involved. It may be a suit of civil nature if it is not purely based upon a decision of a religious question. The next question is, section 9 is based on the maxim, and you all very well know section 9 is based on the maxim ubi jus ibi remedium. So therefore the correct answer is option C. Okay. Section 9 of the CPC is based on the maxim ubi jus ibi remedium, which means that where there is a right, there is a remedy. Where there is a right, the violation of it is a wrong, and when there is a wrong that has happened, the remedy has to be provided. Okay? The subject matter jurisdiction of a civil court extends to what categories as has been mentioned? The subject matter jurisdiction. It is talking about the subject matter jurisdiction of a civil court extends to all claims of civil nature. Then all claims of civil nature, unless their cognizance is expressly or impliedly barred, all suits of a civil nature which by express provision of a statutory law or by common law falls within the jurisdiction of civil court, only those claims of a civil nature where no other forum, authority or tribunal has jurisdiction. So you have to select the most appropriate answer among the available options. So the most appropriate seems to be the option B, all claims of a civil nature unless their cognizance is expressly or impliedly barred. Okay? So this is the correct answer. Section 9, again, the same explanation is there. The court shall, subject to the provisions herein contained, have jurisdiction to try all suits of civil nature, excepting suits of which their cognizance is either expressly or impliedly barred. Okay? Which one of the following is not suit of civil nature? जैसे अभी आपको मैंने बताया था, if a suit is totally dependent upon decision of a purely religious question, it will not be treated as a suit of civil nature, and then the jurisdiction will be barred upon a civil court of taking cognizance of that case. But if it incidentally involves any religious question, then the civil courts can try such suit. अब कौन सा पूछ रहा है, which one of the following is not a suit of civil nature? Suit for rights to hereditary offices. Obviously, it's a civil right, this is involved. Suits for rights of franchisee, obviously a civil right is involved. Suits for recovery of voluntary payments or offerings. Here we have to see. Suits relating to right of worship. Right to worship is a civil as well as a constitutional right. But here if we see, suit for recovery of voluntary payments. If a person has voluntarily given some offerings in a temple, he will have no such right which is legally protected. So therefore, such suits will not be a suit of civil nature. Okay? So that will be the correct answer, suit for recovery of voluntary payments or offerings. Suit for the recovery of voluntary payments or offerings is not a suit of civil nature because such payments are made without any legal obligation and are considered as a charitable or a religious act. Then we come to the next question where you have to select the incorrect statement. Mark the incorrect statement. A civil court has jurisdiction to try all suits of civil nature unless barred expressly or impliedly. Consent can confer or take away jurisdiction of a court. Decree passed by a court without jurisdiction is a nullity. Burden of proof of exclusion of jurisdiction of a court is on the party who asserts it. So यहाँ पे जो गलत statement है वो आपको mark करना है. Civil court has jurisdiction to try all suits of civil nature. This statement is correct unless the jurisdiction is expressly or impliedly barred. Decree passed by a court without jurisdiction is a nullity. A decree which is passed without jurisdiction goes into the root of the matter, and therefore such decree which is passed without jurisdiction is a nullity. This is also correct. Burden of proof of exclusion of jurisdiction of a court is on the party who asserts it. The party who says that the court does not have jurisdiction to try a particular case, the burden of proving that the court does not have the jurisdiction is upon that party who says that the court does not have the jurisdiction. Okay? So this appears incorrect. Consent can confer or take away jurisdiction of a court. Consent can neither confer any jurisdiction upon the court nor take away the jurisdiction of the court. Okay? So this is the incorrect. and therefore you have to select it, and it's the correct option. Consent can confer or take away jurisdiction of court is this statement is incorrect, and therefore the right answer. Consent can confer or take away jurisdiction of court, it's incorrect because jurisdiction is determined by the law, and consent of the parties can neither create nor take away the jurisdiction of a civil court. Now we come to another question wherein it is based upon case law, and it's a very leading case upon this subject. 𝐒𝐂𝐑𝐈𝐁𝐄 versus State of MP is related to which of the following under the CPC? Jurisdiction, pleadings, interim orders, or first appeal. So you must be knowing it's related to the jurisdiction of the civil code under section 9. Okay? This is pretty much self-explanatory. 𝐒𝐂𝐑𝐈𝐁𝐄 is primarily related to the jurisdiction of civil courts. Under the Civil Procedure Code, specifically it addresses the issue of whether civil courts can retain jurisdiction to try cases involving validity of tax laws even when there are statutory provisions barring such jurisdiction. The next question is whether court can without exception try all suits of civil nature. So this is very much easy, as we have already read section 9. So there is exception that is there under section 9. So the answer would be no. Okay. If their jurisdiction is either expressly by any statute or by impliedly, if there is any provision by which the remedy is provided, then it might be impliedly barred. So these are the exceptions. Courts do not have unlimited jurisdiction to try all suits of a civil nature. They have the jurisdiction to try all suits of civil nature, but this is subject to exceptions. Specifically, the courts cannot try suits where their jurisdiction is either expressly or impliedly barred. Then we have the last question. For determination of an objection under section 9 of the CPC, the court is to primarily see the averments made in which of the document? जब भी जुरिस्डिक्शन के ऊपर कोई क्वेश्चन होता है, कोई ऑब्जेक्शन होता है, तो कोर्ट इन दिए गए डॉक्यूमेंट्स में किसको देख के वो उस ऑब्जेक्शन को डिस्पोज करेगी? सिर्फ प्लेंट को देखेगी कि प्लेंट और रिटन स्टेटमेंट को भी देखेगी, प्लेंट रिटन स्टेटमेंट रेप्लिकेशन को देखेगी कि अवर्मेंट्स देखेगी इन द एप्लीकेशन फॉर रिटर्न ऑफ द प्लेंट? सो द करेक्ट आंसर विल बी द कोर्ट विल बी ओनली बी रिक्वायर्ड टू सी the plaint. Okay? Answer is A. Here we see the explanation. For determining an objection under section 9 of the CPC regarding jurisdiction, the court primarily considers the averments made in plaint only. So यहाँ आपको confuse नहीं है होना है कि plaint और WS क्या दोनों देखा जाएगा? नहीं, सिर्फ plaint के averments देख के jurisdiction के objections को determine करना कोर्ट का काम है. Okay? So that's all for today. Do like, share and subscribe our channel and stay tuned for more updates. Thanks a lot.